Good morning, everyone. Welcome to Second Tuesdays at PERB. This morning's discussion will be on collective bargaining and, the duty to bargain and the duty to provide information. And we have someone, Mr. Hathaway? Thank you. Mr. Hathaway was kind enough to provide us with some refreshments. You need to know that PERB did not spend any money on food, but Mr. Hathaway was gracious enough to...
I didn't disclose that information to anybody.
Right. Well, it's hard for us not to recognize a nice gesture. All right. So we've got these donuts over here, and we do provide water, but we have some donuts over here if you'd like to get one or two before they disappear. And I'm going to turn everything over to Mr. Higgins.
Good morning. Mr. Hathaway, raise your hand. All my Lenten plans just went down the drain. Get behind me, Satan. Get behind me, Satan. Any event. That's it. We'll call it Fat Tuesday again. Okay. Good morning. Today we're going to, as Clarine said, we're going to talk about the duty to bargain. And this is a big subject. In fact, I'm the author of a book called Developing Labor Law. It's a 2-volume text on labor law put out by the Bar Association and American Bar Association. But my point in mentioning this is that Chapter 13 deals with the duty of bargain, and it is clearly the biggest chapter in the book. It is a monster. It is at least half again longer than any of the other 33 chapters in the book. So this is a big subject, and to try to do it in a little over an hour and a half is going to be pretty hard, but I'm going to try. Those of you who were here last month know that we started on the duty to bargain when we finished the duty of fair representation. But I'm going to start over again. Okay? I apologize. I just want to make sure everybody realizes what's involved. We didn't get that far into it. And the problem was in the afternoon session, I never got to it. So if you happen to have been an afternoon person who shows up this morning, you weren't here last time, so or you didn't get it last time. So I'm going to start over again. As I say, it's a big subject. I'm going to divide it into. I've divided it into 4 topics, and I'm going to just cover them one at a time. The first is the doctrine or the concept of exclusivity, and I'll tell you in a minute what I mean by that. The second concept will be the standards for bargaining. Basically, we're going to talk a little bit about what does it mean when the statute says good faith bargaining. You must bargain in good faith. What does that mean? And more importantly, how does PERB know whether you're in good faith? That's, I think, the real hard part. The third subject that we're going to talk about is the subjects of bargaining. What do you have to bargain about? What can't you what can you bargain about, but you don't have to? There are some things like that. And then there are what can't you bargain about at all? What are illegal subjects? We'll talk about that. And then the last thing, as Clarine said, we're going to talk about the duty to supply information. I think probably more people spends more time on this particular subject than on any other subject in this area, and so we'll spend some time on it too. And I'm going to use that as an opportunity to talk a little bit about what my reaction has been to reading the PERB cases. In some cases, yes, ma'am. The duty to supply information. Okay. I've been reading a lot of PERB cases the last 2 or 3 months with respect to the duty to supply information, and some of them, frankly, I'm just amazed that some people the way some people approach this duty to supply information. It does not have to be the nightmare that everybody seems to treat it as being. Okay. So anyway, those are the 4 things. Exclusivity. What does it mean? Well, it means, let me see. Specifically, it means that the union speaks with one voice. The union is a union. It's one. Okay, it's one. And the whole concept of collective bargaining is really grounded in this doctrine of exclusivity. Whether you call it collective bargaining or you call it exclusive bargaining, it means one thing, and it means that when a union is certified, it is the collective bargaining representative for all. It speaks for one. It speaks for one. So, what are the problems in this area? Well, the problem, of course, is when the problems arise in the unfair labor practice area, when an employer seeks to undermine that exclusive relationship. And usually that comes about, when it comes about, is when the employer engages in direct dealing. Okay, direct dealing. What do I mean by that? Well, I'm going to tell you about 2 cases. They're very old, and they're very hard to reproduce them in 2015 D.C. government employee circumstances, because they go back to 1944 in their private sector cases. But they were important enough to go to the Supreme Court. One is a case called J.I. Case, and the other was a case called Meta, M-E-D-A, Photo. J.I. Case involved a situation where the employees had individual employment contracts with the employer prior to the time the union came in. So when the union came in and the union won the election, the employer says, well, I can't really bargain with you about these people until their contracts expire, because I have an employment contract with them. And the Supreme Court says, sorry, no. Your employment contracts cease to exist when the employees voted for a union. Those employees are now represented by a single union. They speak with one voice. Forget those individual contracts, okay? The second case was a case called, as I say, called Metaphoto. This could happen a little bit in today's world, where the employees and the employer and the union are engaged in collective bargaining for a contract, and some employees come to the employer and they say, hey, quietly, by the way, outside the relationship with the union, they come to the employer and they say, we'd like to get a raise. That's really why we brought this union in here. If you'll give us a raise, we'll kick this union out. The employer says, sounds good to me. And he did it. And that was an unfair labor practice. In both those cases, okay, the employer was, quote, directly dealing with, close quote, the employees, and not dealing with the union. In the first case, he was continuing to deal with them directly by wanting to honor those individual contracts. In the second case, he was dealing directly with them because he was, in a sense, bargaining behind the union's backs with the employees. And both of those are unfair labor practices, and both of those are denials of the doctrine of exclusivity. There was one case not too long ago, about 2010, I guess it was, is a DC Family Service case that involved it's a PERB case, involved a RIF, and there was a RIF, and then the agency was going to create new jobs. So, at one point, while this was going on, the employer sends an email out to all the staff, bringing them up to date on what's going on. By the way, there is a union there, okay? But he sends the memo directly to the employees, and he says, you know, I laid off X number of people. We are now in the process of rehiring and restructuring, and we brought in 25 more people, but they're going to be in different kinds of jobs. And so that's what's going on. The union filed an unfair labor practice saying direct dealing. What do you think? By the way, I would tell you this. PERB never got this case. A hearing examiner from PERB got the case, and he issued a decision, and it was never appealed to PERB. So I can't tell you what PERB would have done, but I can guess. But what do you think the hearing examiner did? Anybody want to take a stab at this? Is that direct dealing?
No, I would say no.
Why?
Because it's just notice of a decision.
Yeah. There's nothing wrong with talking to your employees. Yes, ma'am. You're exactly right. And that's all the employer was doing. He did it by email. But there's nothing wrong with talking to your employees and telling them what's going on. But don't be very careful, because if by telling them what's going on, you're really secretly in your heart of hearts hoping this is going to lead them someplace, then when they react to you, you better be careful you better talk to your lawyer. That's what you better do.
In Metaphoto, what would the employee liability have been towards the union? Could the union bring a claim against the employees for reaching out to the employer to try to get rid of them?
Well, I suppose they could kick them out of the union, I suppose. But they're still in the bargaining unit. I mean, if they could make them non-members of the union, but being a non-member of the union only means you can't go to the meetings, you can't go to the picnic, you can't go to the Christmas party. It doesn't mean you don't get all the contractual benefits. Yes, sir?
Could that also be perceived, that them having that conversation, as leading or trying to persuade them in some sort of way?
You mean in the DC PERB case that I mentioned a moment ago?
One in having that conversation.
Well, I don't know what PERB would have done if it got that case. But I tell you that the hearing officer dismissed the unfair labor practice complaint, because he said, as this lady just said, he was really talking. He has a right to talk to employers. Have a right to tell their employees what's going on. Okay, they just can't deal directly. But going back to this question, for those in the back, the lady just asked me, well, is there anything the union could have done, or is there anything that bad happens to the employees when they are direct dealing? And the answer to that happens to be a Supreme Court case of about 20 years ago, a case called Emporium Capewell. If you've ever lived on the West Coast, you know I think the Emporium Capewell is a department store, if I remember correctly, in the Bay Area, in the San Francisco area. And in this case, there were a group of employees who were very unhappy with the employer's EEO program. They really felt the employer was not fair, or did not have a fair EEO program. And so they began to campaign against the employer. And by the way, there was a union, and the union and the employer were engaged in collective bargaining. These employees started to picket the employer's premises, not on behalf of the union, but on behalf of themselves and their EEO cause. Okay? They also had an anti-employer campaign and so forth and so on. I'm not going to try to get into all the details. The point here was the employer says, you know, I don't think that's protected activity. I don't think that's activity that they can engage in and get away with it. And so, you know what I'm going to fire him. And he did. And they came to the NLRB and they filed an unfair labor practice charge. And the charge alleged that this was protected activity. EEO activity is protected activity. And indeed it is. In other words, when an employee engages in EEO activity, he or she is protected by the National Labor Relations Act, also protected by EEOC. The board found a no violation of the act. Case ended up in the Supreme Court, and the Supreme Court agreed. What the Supreme Court said was, there's a fine line here, but these employees stepped over it. What they were doing was they were seeking to deal directly with the employer. They were seeking to undermine the union. They were in the unit, and they don't have a right to try to deal directly with their employer on this subject. This is a subject that they can go to the union meetings and they can raise hell if they want that the union's not doing enough. Okay, they can resign from the union, they can do all sorts of things, but they can't try to undermine the relationship between the employer and the union. And that's what the Supreme Court saw them as doing. And so that's a violation of the National Labor Relations Act. And that's an example. I mean, that kind of a case comes up once in about 25 blue moons. I mean, even more than that. But it is a case that was important enough to get to the Supreme Court. And it's important, you should know about it. So direct dealing is a two-way street. You just don't very often run into the kind of situation that they had in Emporium Capewell. Now, everybody got his blue book. If you looked at your blue book, you'll know that there are situations where the employees can actually talk to their employer directly without having the union speak for them. Anybody know what that is? Well, if you look at well, I don't want to spend a lot of time on it. Look at 617.06B. That's really a carbon copy of a provision in the National Labor Relations Act. And what that says is that an employee has, notwithstanding the fact that the union is the exclusive bargaining representative, an employee can go sit down with the employer and discuss a grievance, can present a grievance directly to the employer. He doesn't have to go through the union. Okay? Does not have to go through the union. The union has a right to be told that there's going to be a meeting. The union has the right to sit in on it. The union has a right to say what it wants, but the employee is representing himself or herself at that meeting. Now, and by the way, the employer and the union, excuse me, I'm sorry. The employer and the employee can actually settle a grievance. Okay? But unless the union signs on to it, it cannot be precedent for future grievances. Okay? In other words, it doesn't bind the union's hand. Now, let's understand what we mean by grievance. Here we mean grievance with a very, very small g, not a capital G. That is, this is not a grievance that, like you're thinking about, under your collective bargaining agreement, where it can end up in arbitration. Because this employee can't take the case to arbitration under 617.06B. It's grievance. Let's use the word grievance. Let's use the right word. Beef, complaint, gripe. Okay. He can talk to the employer about it. He can try to work out his problems. But if the employer just tells him, get lost, okay, he can't say, okay, we're going to arbitration. That's not that kind of a grievance, okay? But that's not what 617.06B is talking about, okay? All right, I'm going to move off exclusivity. Questions about those? Yes, sir.
Having been denied a remedy for a trivial grievance, the employee could then, provided the contract provides for this, for example, file a formal
Absolutely.
grievance.
Absolutely.
Right.
He could file a grievance with the, he could absolutely file a grievance. I suspect there might be a time problem here, because I'm sure that by the time he gets to the employer, has his meeting, they tell the union about it, the union has time to come to the meeting. I suspect by that time the time to file a step one grievance may have expired. But if it hasn't, it certainly would not prohibit him from doing that. Okay? Any questions? Other questions? Okay. We're moving to the second topic. What are the standards for bargaining? Okay. Well, the basic standard is, as CMPA says, it's you've got to engage in good faith bargaining. What does that mean? Well, it's been defined in many ways. I'm going to give you two of the definitions coming from some of the cases. And the first is, and I quote, good faith bargaining is a, quote, sincere desire, an open mind, and a sincere effort to find a basis to reach an agreement. Okay? Go to the bargaining table. You really want to reach an agreement. Doesn't mean I'm going to the, if you're going to the table and say, I'm going and I'm going to get mine and this is my position and there ain't no other position, it probably is not good faith bargaining. Okay? That just is not good faith bargaining. That is, you're looking for, you need to go there with a sincere desire, an open mind, and a sincere effort to find and reach an agreement. Okay? The second definition, a bona fide, or which is another word for good faith, a bona fide intent to reach an agreement, close quote. Okay? Now, if you look at your Blue Book and go to the unfair labor practice sections of the Blue Book, you will see that unions have the same obligation as the employer. So good faith bargaining is a, and this one is, a clear two-way street. Okay? The CMPA, the National Labor Relations Act, the Railway Labor Act, they all contemplate unions and employers sitting down at the table and both trying to reach an agreement, or both having a bona fide intent to reach an agreement. In a case that PERB issued in 1999, it involved a DC Department of Recreation and Parks. PERB laid out what it's looking for. What are the elements of, or what are the elements of bad faith bargaining? What does an employer do? What can an employer do that would end up him getting the short end of a stick, or vice versa, the union? And I'm going to read from it. It's not very long. We, PERB, look to precedent under the National Labor Relations Act to provide guidance on what factors to consider when examining this issue. To establish surface bargaining, and that's the term that they use, surface bargaining. That means, that, by the way, means sitting down at the table and just going through the motions. On the surface, it really looks good, but it ain't, okay? But it ain't. That surface bargaining is bad. It's the opposite of good faith bargaining. All right, I'm going to go back to the beginning, read that sentence again. To establish surface bargaining, no one factor is determinative. Rather, the totality of a party's actions during collective bargaining must be examined to determine whether or not a party's conduct establishes a purpose or intent to frustrate or avoid reaching an agreement. A single fact, I'm continuing now, this is PERB speaking, not John Higgins. Any single factor standing alone usually will not demonstrate bad faith. Also, the fact that extensive negotiations fail to produce a contract does not justify an inference that the employer is engaged in bad faith bargaining. Okay? So no single thing necessarily means that it's going to be bad faith bargaining. And the fact that the parties work hard, they never reach an agreement, the union says, well, we've been at the table, and the fact that we don't have an agreement just shows you this guy's in bad faith. PERB says, no, that's not enough. Now, obviously, these are very hard cases. By the way, that's H-A-R-D. If my Boston accent is throwing anybody off here. These are very hard cases, okay? Because what PERB is being asked to do in these cases, and what the NLRB is being asked to do, is to get inside the head of the bargainers, to see if they are going through the motions. As I say, sometimes getting in the head of the union. Find out whether the union's in bad faith. Find out whether, so what is the board, PERB, NLRB look to in deciding? Well, I'm going to mention 7 things. 7 things, okay? As Perb says, no one of which is indicates necessarily bad faith bargaining, but it can. It can, okay? The first one. Number 1, delaying tactics, okay? An employer or a union stalling about getting to the table. Putting off meetings, endlessly putting off meetings. Obviously, you know, every management bargainer has a child who's going to be graduating from high school and may have to put off bargaining. The union has a child or a wedding anniversary and is going to have to put off a meeting. I mean, those kind of things everybody understands. But delaying tactics as a strategy can be evidence of a bad faith bargaining. Terminating meetings just jumping up at the middle of a meeting and walking out. Okay. Now, we all get angry. That's part of bargaining. Management knows when the union is putting on a little bit of a show. The union knows when management's putting on a little bit of a show. Everybody gets angry now and then. Again, this is not what we're talking about. We're talking about where they terminate meetings as a strategy, and it happens more than once, I guess. Number 2, unreasonable bargaining demands, such as regressive proposals. Regressive proposals. Now, in DC PERB, you know, most of the bargaining is not going on. You're not talking about wages. Okay, that's being done by compensation bargaining. But in the private sector, that would mean sitting down at the table and say, the employer says, my first proposal is to cut wages 25%. Really? Well, I mean, now, if the employer has a really good reason for that, I mean, if the employer is on the rocks or virtually on the rocks, that's not a regressive. That's regressive, but it's not a bad thing. The employer is trying to save the company. Okay, but an employer a wise guy who goes to the table and says, I want to cut wages. I want to eliminate the arbitration provision of this contract. We don't need a third party coming in here and telling us what to do. You know, I own this business. I'll make the final decision. We've had an arbitration clause in this contract since the year 1. I don't care. Well, like as not, that's an employer who's trying to duck his collective bargaining relationship. Yes, ma'am.
Seems like the line there between taking an aggressive stance versus a regressive is the word you think you're using. I'm not sure I quite understand where that line is going to be.
Oh, that's the problem.
Right.
That's why I say it's hard.
Yeah, for example, I remember someone telling me a story. They were negotiating with workers who they were predominantly Rastafarian, and so the management decided to impose a drug testing program. This is 20 years ago, because they knew that smoking marijuana was a big part of this culture, so they imposed this tactic. They hadn't planned to do it, but they put that forward as a way to get the union to back off on something else they really wanted, and then they pulled it back.
Well,
would that be?
Well, now we're getting into the difference between bad faith bargaining and just plain old good faith strategies.
Right.
You know, how do I get them to how do we get to yes? How do we get to yes? And again, no one thing. I mean, no one thing. If that were all, and if the real plan was, the employer's real plan was not that he was trying to undermine the union or cut the union out of it, but this was his way of trying to get a contract.
Right.
He wants to get a contract. Probably not an unfair labor practice, you know. It ain't nice. Maybe it isn't nice, but it's a strategy. You know, it could very well be. I hard to tell. Item number 3. But by the way, let me back up just for a second on that. The hypothetical that I just gave you, not the Rastafarians, but the hypothetical I gave about taking the arbitration clause out of the contract, that implies that there's that there was a contract beforehand. A lot of these cases come up in more in initial bargaining than in contract renewal bargaining. In other words, the union wins the election, the employer has to sit down for the very first time with somebody else. Now, with somebody, the owner of this company now has to sit down with somebody who he thinks doesn't have any stake, doesn't care about, all they care about is dues. That's what the employer's saying. All they care about is dues, you know. Regressive bargaining there would be, not necessarily denying arbitration. That's understandable in that circumstance. The employer says, look, I've never had a union before. I'll go along with the grievance procedure. And I'll go along with maybe arbitration for a discharge, but not for anything else. Okay? Anything else I want to call the final shot. Well, it's understandable while the employer is trying to feel his way along with this new element in his factory, this thing called the union. But again, it's no one. You've got to examine the bargaining in the context in which it took place. Is it a new first time bargaining, or renewals? And so each case deserves to be treated separately. Unilateral changes. Unilateral changes on the way I've written it on my notes here is unilateral changes on mandatory subjects.
That's number 3.
Number 3, yes, sir. Number 3, unilateral changes, mandatory subjects. I'm going to just skim over that a little bit because I'm going to be talking about unilateral changes later on when I get to the subject of bargaining. But unilateral, just quickly so you understand, that means that the employer who has an obligation to bargain with the union about wages, not hours in DC government, by the way, wages and conditions of employment, or wages and hours, but they do that through the compensation board, not at your table. Unilaterally, in other words, without any consultation with the union, without any bargaining, just changes a working condition. Boom, just changes it. Okay? Changes the parking policy at the office, at the area, something like that. So you pick it. That's what I'm talking about. Unilateral, one-sided. That's what it means. Okay. Number 4. Bypassing the union. Bypassing the union. And we just talked about that. That means ignoring exclusivity. So I don't need to spend a lot of time on that. Number 5. Sending people to the bargaining table who don't have any authority to reach an agreement. Now, this can be a tough one. Again, it's in a course as short as this, it's really almost impossible to define it. But what it means is, okay, I mean, no person at the bargaining table usually has a right to actually sign the contract right there. They all work. Everybody works for somebody else. The union works for the members. The union lawyer works for the union president. The employer lawyer working for the agency head. So they got to go back and clear things. But sending people to the table who are nothing but errand boys or errand girls, just bringing the things back, and that's unlawful. Okay, that's unlawful. Okay, so they need to have some role in deciding this. Number 6. Withdrawal from already agreed upon provisions. Withdrawal from already agreed upon provisions. Okay, so they're bargaining and they reach an agreement on something, and usually what happens is they usually initial it. It doesn't mean that it's not going to be final until we get an overall contract, is usually the way the deal is. But then the employer walks in out of the clear blue one day and says, that provision we agreed to on the hours, I've changed my mind. I'm pulling back. Well, is that a bad faith bargaining? It's certainly a sign of bad faith bargaining. It's certainly a sign. Now, if the employer has a good reason, if something just happened overnight or last week that prompts this employer to have to do it, it's a real good business reason or a good government reason or an agency reason, then it might be okay. Again, you have to look at everything in context. And lastly, number 7, injecting new proposals into negotiations. You know, you've been sitting there for a month now, hammering out a contract, and then all of a sudden the employer or the union drops a new proposal on the table. Just out of the blue. Just boom. Where did it come from? And it's not an easy one. Let's assume it's a blockbuster. Okay, it is a blockbuster. And the employer says, "Oh my God!" The employee union says, "We had a contract here. Now we're almost back to square one with this thing." Now, can that be okay? Again, it can be okay if there's a real good reason, good faith reason why it came up then, not a month before. But there better be. There better be. Okay. All right, yes, sir.
So most of these examples are like contract negotiations. Does any of these things apply to like I&I bargaining?
Yes, well, yes, absolutely, the same thing would happen. Except that, usually in I&I bargaining, there aren't a lot of things that can be changed. In other words, the employer,
It's kind of like the employer just telling you, okay, you want to make this change.
yeah, but all of these things apply in I&I bargaining, yes, okay? Not quite the same way sometimes because there aren't usually as many subjects on the table. It's just a little bit different, but the PERB or the NLRB are going to be looking at this same kind of stuff if there's an allegation of unlawful practice, okay? I wrote in my notes here, I'm going to repeat. I wrote it 3 times right across the page. I can't emphasize this enough. What PERB's looking for and what the NLRB is looking for, are looking at is bargaining overall, bargaining overall, bargaining overall. If you're taking notes, write that down, bargaining overall, okay? That's what they're looking at. They're looking at the whole shooting match. Now, I want to tell you about a case. It's a case called General Electric. It was a 1960 decision of the NLRB and of the Second Circuit. And I'm going to tell you about it because I am old enough to remember it, but if you're not old enough to remember, it's a case you ought to know just a little bit about. I'm not going to spend a lot of time on it, but General Electric was represented nationally by the IUE, International Union of Electrical Workers. And they had national negotiations. And the head of labor relations for General Electric was a man named Lemuel Boulware, B-O-U-L-W-A-R-E. And he came up with a concept of bargaining that became known as Boulwarism. And it was the rage in the 60s. If you went to a labor law class in any law school, that's what they were debating. Is Boulwarism okay? If you went to a meeting of labor and management officials in a bar association, everybody was talking about Boulwarism. Okay? Everybody was talking about Boulwarism. What was it? Boulwarism was not a wise guy. He was not trying to bust the IUE, but he really bothered him, all this crazy stuff where he had to lowball a proposal, okay? And the union highballed a proposal, and they both knew that wasn't where it was going to end up. You know, it was like, what's his name? What's the guy that just signed with the Dolphins? So, yeah. I mean, it wasn't like coming in with a proposal like he came in with a proposal like that. He got it. How he did it, I mean. But anyway, no. But he said, this is a game, and we know it's a game. Management knows it's a game, and union knows it's a game. And he said, I'm not going to play that game anymore. What I'm going to do is I'm going to go out and survey the employees about what they're interested in. Then I'm going to go to all of our competitors, Westinghouse and everybody else, and see what they're paying. Then I'm going to sit down and I'm going to come up with a proposal that I think is is really a good faith proposal. And the union can take it or leave it, okay? This is our proposal. We're not lowballing this thing. We're doing this after very careful study, okay? Very careful study. And no one ever challenged Boulwar's good faith. No one ever said, hey, Lem, this is, you're not telling the truth. Even the union didn't say that, okay? But the union filed unfair labor practice charges against General Electric. The board found a violation. Case went to the Second Circuit. What do you think they said? Huh? Boulwar won. How many think Boulwar won? 1, 2, 3, 4, 5. Okay, everybody think, anybody else?
As long as it was good faith.
Well, okay, so you think he won. How many think he lost? The losts have it, okay? And this is a very hard thing to say because what the board says, this is just not what the Act contemplates. And that's what PERB would say. This is just not what CMPA contemplates. CMPA contemplates an exchange of ideas, not someone walking to the table and say, that's it, just take it or leave it. No, no, no. And so again, this kind of brings us back to what is good faith bargaining. It's an overall effort to try to reach an agreement, but to do it through bargaining and not through an edict, not through a mandate. Yes, sir.
Was the surveying of its own employees, was that taken into consideration at all?
No, it was not considered part of the unfair labor practice. Yeah. But that could be a problem. But anyway, all right. Now, up till now, we've been talking about going through the motions and so forth, and these are all cases where the PERB's job and the NLRB's job is to get into the head of the parties. I want to talk just for a second about things that are per se unfair labor practices. In other words, if you do them, they're bad, even if your heart's in the right place. Okay? If you do them, they're bad, even if your heart's in the right place. And one of those is what we said a little while ago, unilateral change. That's a change in wages, hours, or working conditions that's done without notification to or bargaining on demand with the union. Why is this bad? Why is this bad? Well, it's bad because for really 4 reasons. It violates the plain meaning of the statute, which means that the employer has an obligation to bargain or deal with the union. Second, it really injures the concept of collective bargaining. It really is, it's anathema to collective bargaining. Third, it minimizes the influence of organized bargaining, and that's really what bargaining is all about, is to try to get the employer to get its position on the table and the union to get the employee's position on the table and reach something that both of them can live with. And fourth, it emphasizes to employees that suggests, or at least that collective bargaining is useless. So those 4 reasons are really why unilateral changes are unlawful. Well, so let's, when is it okay for the employer to do it? When is it okay for the employer to do it? Well, when it's covered by the contract. When it's covered by the contract. In other words, when the union and the employer have agreed that the employer has a right to make the changes without coming to the union. It could very well be there's a lot of those kind of provisions often in contracts. Okay, very well be. Or it can be a statutory, mandatory management right, a statutory management right. Okay, we'll talk about those in just a few minutes. But those things don't exist in the private sector, but they do clearly exist in the PERB. They clearly exist before FLRA in the public sector. Most public sector statutes have management rights, rights that management has, and permits their management to make changes without bargaining with the union about it. My friend over here, before he raises his hand, he's going to say to me, well, what about is there I&I bargaining there? And the answer is yes, and we'll come to that in a minute, okay? But the second time, and it's in the private sector, not at PERB. The other way, it's either covered, if it's covered by the contract, that's one. The second would be if management and the union bargain to impasse, and they can't reach agreement, a good faith impasse. Can't get there. The employer is privileged to make the change. In that sense, it's not unilateral because he doesn't do it without notification to the union. He indeed talked to them about it. But let's go back to this covered by the contract, because there's a very interesting element in PERB collective bargaining law that you should be aware of. I'm talking about a 1994 decision of PERB. It's a UDC case, okay? And I'm going to read to you a kind of a long sentence. It's only one sentence that PERB wrote about this. Relief from an alleged misapplication or a change in a practice that is specifically covered by the effective collective bargaining agreement lies not within the statutory authority of the board, but in the available rights and obligations arising from the collective bargaining agreement. Now, the particular facts in that UDC case were a change in practice. Actually, there were two issues in the case. One was a change in practice of the employment of unit members, and by the way, these were full-time faculty. How it was decided whether they would teach courses that would otherwise have been taught by part-timers, okay, by adjunct faculty. The other issue in the case involved a change in the criteria for offering summer school courses. And the collective bargaining agreement at UDC at the time read, quote, qualified faculty in a department may request to be assigned one course for which a part-time appointment would have to be made. The university has discretion to grant this request. More recently, in a case that was 1993, and you say, "Wow, God, that's old. That's 20 years old." Maybe PERB's changed his mind. No, they haven't. More recently, in a December 2014 decision, PERB says, a unilateral change in established and bargainable terms and conditions of employment does not constitute an unfair labor practice when such terms and conditions are specifically covered by the collective bargaining agreement. By the way, that case was called as a Department of Mental Health case, PERB number 14-U-14. Here there was union. There was past practice was there was leave to attend union-sponsored programs, and the contract said employees may be granted administrative leave to attend union-sponsored programs and trainings if the Office of Labor Relations approves. Okay, that was what the clause said. The department changed that from giving 100% time to 50% time. By the way, anybody involved in this case might tell me if I'm saying this wrong. And the union said, oh, no, you can't do that. That's a unilateral change. 100% was past practice. And the PERB says, yeah, that's right. But past practice is part of the contract. Past practice is in the contract. And so if you've got a beef about this, don't come to PERB, go take it to arbitration. Did I say it right? Okay, perfect. Now, not all past practice unfair labor practice charges or unilateral change cases are covered by the contract. So this is something, you know, this is really, I'll bet you I could spend the rest of the month talking about this particular problem. I'm going to have to leave it at that. The simple answer is, you just got to look carefully when you have one of these kinds of cases, and talk to your lawyer. Talk to your lawyer. But that's what PERB law is. By the way, one other case, just to give you another fact pattern. The board did find a violation when the employer changed the excused leave to vote provisions of the contract. The union claimed that it was past practice and that was beyond what the DC Personnel Manual allowed. I mean, it was less than what the DC Personnel Manual allowed. And the contract itself actually referenced the DC Personnel Manual. So you would have thought, oh boy, well, this is another one of those cases. Well, the hearing officer found and the board found a violation. The kicker in this case, there was no answer filed. Okay, the Department of Health did not file an answer to the PERB complaint. So it was a default judgment, but even in those circumstances, the fact that the actual contract clause referenced the DC Personnel Manual seems to me would have suggested that this was a case covered by that UDC decision. For some reason or another, without explanation, PERB found a violation. Do you know why? Do you remember the case?
That's not my case.
Oh, okay, all right. All right.
First one was.
All right. And finally, I just want to go back. This whole problem of obligation to bargain about unilateral changes extends to unions. Okay? Unions can't engage in unilateral action. Now, how often does it happen? Not very often. Very, very seldom, as a matter of fact. I think I was with the NLRB for 47 years. And I think I don't know how many of those cases we had, probably 2, maybe 3. And they don't usually come up in an industrial situation. They very often usually come up in a construction situation where the union and the employer have a collective bargaining relationship in a hiring hall. And the union makes some change in how they're going to refer people out from the hiring hall. In other words, what kind of people the employer is going to get. And the employer says, wait a minute, that wasn't what I bargained for. The union says, hey, we decide who's going from our hiring hall. Well, that could be a unilateral change, but it can happen. Does anybody here have any kind of a collective bargaining relationship with any union that supplies workers to you on a temporary basis? Do you have anything like that? Okay. Well, do you have your relationship was with the union, right?
Yes.
Yeah. So that could happen. You could actually have a unilateral change if the union all of a sudden decided that the deal was you want them to have high school diplomas, and that was what you want. You were only refer people with high school diplomas, and the union unilaterally says, hey, we know better. We're going to use GEDs. That wasn't the deal you struck. I mean, I'm making this up a little bit, but that could actually happen in that circumstance. Okay. I'm moving on to subjects of bargaining. We're halfway through. I'm going to talk fast though. There's a lot more to go. All right. Anybody? Any questions about what I've said so far? Yes, sir.
What are the penalties to these ULPs?
Well, okay. Okay. Well, there aren't any. There aren't any. Because you use the word penalties. Penalties suggests punishment. Okay. The root is the same word from the Latin word for punishment. Okay. There are no punishments under the National Labor Relations Act, and there are no punishments under the CMPA. Okay. What there is are remedies for these unfair labor practices. So, employer fires somebody for union activity. Okay. Okay. What does PERB do? Well, does PERB punish the employer for doing that? No. What PERB does is it remedies that unfair labor practice. It tells that employer, that agency, put this guy back to work, give him his job back, give him back pay, okay, for what he lost. And if he, by the way, while he was off, he was driving a cab for his brother-in-law and made more money than he would have made if he was working for that agency, he gets no money. Okay? Okay. So he only gets what he lost. Only gets what he lost. and they have to post a notice in the office saying we won't do this again. So that all the employees who are the subject and know about that unfair labor practice will know that PERB caught them and the employer is saying I won't do it again. Now, again, those are not penalties. And the National Labor Relations Act is not a punitive statute either. It is a remedial statute. It remedies. This is something that irritates the heck out of unions. They were always trying to the idea of putting in penalties, fines for doing that. You know, make them hurt.
Right.
That's not what Congress decided. That's not what the D.C. City Council decided when they passed the statute. Okay. All right. We're moving on to subjects. This is a sort of a way of repeating what we were talking about in the unilateral change case. What it means is, what are the subjects that you have to bargain about? When you sit down at the bargaining table, what does the employer have to bargain with you about, and what doesn't he have to bargain with you about? What does, for that matter, the union have to bargain if the employer would like to bargain about something? Okay? Now, this is not going to be a class in compensation versus non-compensation bargaining. I suspect almost everybody in this room knows more about that than I do. So what I'm going to be talking for a lot of times is be talking mostly about private sector, although there are a lot of subject cases before PERB. Let me start off by saying the subject area, the concept of subject of bargaining is divided into three parts. Okay? Part one, mandatory. The things that you must bargain about if you are an employer or if you are a union. Okay? Now, do you have to raise them at the table? No, but if the other guy raises them, you've got to talk about them. You've got to bargain about them. Okay? The second one is permissive. The things that the union can raise and you don't have to bargain about if you don't want to, or vice versa. Okay? In other words, but if you want to bargain about them, that's okay. That's okay. Okay? And the third thing is illegal subjects. Things that just aren't right, aren't good. Now this all comes from a Supreme Court decision, a case called Borg-Warner. It's a 1958. I think it was 1958. I remember the years now. Believe it or not, it was before my time. There was a period before my time. But it's a case it's a concept that PERB has adopted. If you want to look at a case called DC Nurses 12, it was a 1982 decision, but it was reaffirmed as recently as 2013 in a case 13N-03, opinion 1389. All right. Now, what does CMPA say about this subject? Well, if you look at 1.617.08b, the statute says, all matters shall be deemed negotiable except those that are prescribed by this subchapter. Negotiations concerning compensation are authorized to the extent provided in 1-617-16. Okay? Now, does this mean, when it says, all matters shall be deemed negotiable except those prescribed, does this mean you've got to bargain about everything? That employers have to bargain about everything, unions have to bargain about everything? And clearly the answer to that is no. Okay? And if you've already read this book to cover between our sessions, and you got to 617, you read 617.08 in its entirety, you know that there's a provision in there that's known as the management rights section. Okay? What does that mean? It means that there are subjects about which management simply does not have to bargain. Why is that? Because the DC government, in its infinite wisdom, has decided that they don't have to bargain about it. Now, some of them are bargainable, but they are not bargainable at your table, okay? In other words, wages, okay? Wages, of course, is the heart of collective bargaining in the private sector, all right? It is not the heart of collective bargaining between an agency and a union on non-compensation bargaining. That, as I understand it, that wage stuff gets handled in compensation bargaining, okay? Well, let's take a look at a couple of subjects. How many people here have a collective bargaining agreement that includes provisions about hours? This is non-compensation bargaining?
No, compensation and non-compensation are bargained at the same time.
Oh, okay, all right, all right. Do you have a non-compensation contract that has hours in it? Okay, you have one?
We're still bargaining over it,
Okay.
but this is a topic I have a lot of questions about, because I mean, I know tours of duty is something that is part of management rights, but oftentimes I think unions want to bargain over flexible work schedules and.
Well, why don't you, do you know how it ended up in your contract? It's tour of duty.
Well,
Yeah, why is it in the contract?
The reason it's in there is to be able to give, when reasonably exercising notice to the union for impacts and effects of changes in tour of duties, to give adequate notice, and also for the reassignment of representatives from one work site to another, so that they can.
But why did you bother with it? Why did you bother? You don't have to talk about it, right? All right, you don't have to talk about it. You know why that's in there? Because management waived the right to bargain about that, okay? In other words, if you look at those items in 617.08, all those things are management rights that are, well, with one exception, that are waivable, okay? I don't think RIF's waivable, is it? No, I don't think RIF is waivable. But all of those things can be, are things that, if you get it, if you have it in your contract, it's because management agreed to do it, okay? And if you want to, let's see, if you want to read a case on this, if that's something if you're doing this on your own, you might take a look at Local 36 firefighters. All right, a 2013 decision of PERB, and this was not an unfair labor practice case. This was a negotiability case. The question was whether or not PERB, whether or not the DC Fire Department had to bargain about tours of duties. And here's the proposal. What the union wanted was, they had a proposal for the basic work week for members in the firefighting division shall be 42 hours averaged over a 4-week period. Then, another provision that the firefighters asked for. The work schedule for members working in the firefighting division shall be 24 hours on and 72 hours off. And what did PERB say? PERB said, this is tour of duty. And tour of duty, you know, by the way, the firefighters tried desperately to get PERB to make a distinction between tour of duty and hours, and their efforts were unsuccessful. PERB says tour of duty is hours, okay? Tour of duty is hours, includes hours. And what PERB cites in its decision is 617.08A5. Personnel authorities shall retain the sole right to determine, and I'm now going to quote, A, the mission of the agency, its budget, its organization, the number of employees, and to establish the tour of duty. Okay? Also, the number, types, and grades of positions of employees assigned to an agency's organizational unit, work project, or tour of duty. Okay? So, if you have something in your contract, for example, that says work teams, the contract says, work team shall be composed of 8 employees, 4 employees, 5 employees. Anybody have anything like that in their contract? Okay, well, if you did, again, that would be something that management waived. When you proposed that, when the union proposed that, or not you, everybody's a union. When the union proposed that, the manager could have just said, I'm sorry, you just haven't read 5A and B lately. Here's a copy of it. We're not talking about that. Are they privileged to do that? Answer, yes. Okay? Now, but as I say, management can waive. Yes, ma'am.
So between contracts, you had negotiated work duty before.
Did you read my notes? I just what I'm going to talk about right now. I've got you. All right. How long is a waiver good for? That's your question. That's your question. How long is a waiver good for? And the answer is the life of an agreement. The life of an agreement. In a case called, another DC fire case, by the way, fire and emergency, it's an 06 case, PERB described the waiver rule as follows. It has 3 parts to it. The waiver rule is Part 1, management can waive a management right. Part 1. 2, a waiver doesn't mean the right that this is a waiver in the future. 3, but if management waives, yes ma'am?
Can you go back to number 2?
Yes ma'am. A waiver doesn't mean that the right is a waiver forever, or forever in the future. Okay. And the third really explains that a little bit better. If management waives and puts it in the contract, it stays in effect for the life of the agreement. But when the agreement expires, that waiver expires. Okay? Management can renew it, but they certainly don't have to. Okay, you say, I understand what you said, Higgins, but I read 617.08A, paren A-1, and that says no waivers. What are you talking about? Because it says, doesn't it say an act, exercise, or agreement of the respective personnel authorities, management rights, shall not be interpreted in any way, in any manner, as a waiver of the sole management rights contained in subsection A of this section. What does that mean? It does seem a little inconsistent with what I just said. Well, Councilman, is it Mendelson? Chairman Mendelson explained that. And he says, waivers are good. Waivers are alive and well, okay? He said, this new paragraph, and I'm quoting him now, this new paragraph should not be construed as enabling management to repudiate any agreement it has or has chosen to make. Rather, this paragraph recognizes that a right could be negotiated. I don't know how it could be interpreted that way, but he's the city council chairman, and that clearly is the law, and PERB follows that law. Okay? Okay. Questions about that? Because I think management rights probably is something you may want to have. I don't know what we're talking about. All right. Let's go back to our 3 subjects: mandatory, permissive, illegal. Give me some examples, Higgins, about what's mandatory. Well, if you're in compensation bargaining, it says right there in your statute, 6 wages, hours, and working conditions, tours of duty, everything. Okay, all those things are in there. But what about in non-compensation bargaining? Give me some examples. Well, parking, drug testing, grievance procedures, okay. The time for filling vacancies. I mean, there's just a few examples. Probably you could name 25 more, but those are subjects about which management has to bargain. All right, what about permissive subjects? What are permissive subjects? Well, just for openers, there are all those management rights provisions of 617-08. Those are permissive subjects. That is, They can be bargained about, but management doesn't have to be bargained about, okay? They're not mandatory subjects, okay? So just to quickly run through them, lest there be any confusion here. Directing the employees, hiring, promotions, transfers, relieving employees because of lack of work. These are all management rights. Determining the mission of the agency and its budget. Determining the technology of performing work. Internal security practices. So, let's take technology of performing work. Is there anything about bringing new computers into the workplace that management has to bargain with you about? You, if you're a union, has to bargain about. See if I can get somebody else to answer the question. All right, you win. What?
The impact and effects of that.
Impact and effects. Okay, there you are. So even if management has a right to decide that we're going to put in Macs for everybody's going to get a Mac, a laptop. Even if management, there may be the effects of my Mac, by the way, is not working right now. So that's an effect. There may be something the union would like to talk about. Maybe training on Macs, how to be a better Mac person. But those kinds of things, the implementation and impact of that on the bargaining unit. In the private sector, they don't use those words. The NLRB just uses one word. It's called effects bargaining. The effect of and I think it's a better word to it, the effect of that change on the unit employees. Yes, sir.
In the federal sector, they call it impact and implementation.
Right, right.
And there's a test for determining, because sometimes an impact and effects proposal can interfere with the management right. So let's say it's a management right to discipline employees. And maybe an effect of that is the union proposal would say, well, you got to do something in X amount of days. You have to discipline somebody in X amount of days. Or you have to provide the union with a copy of the investigation or something to that level. But in the federal sector, there's a test that says a union proposal is not negotiable to the extent that even though it's an impact implementation proposal, it excessively interferes with the management right. Is there some corollary to that?
I have not found anything, but when I was looking through the cases in PERB, I was looking to see if there were any cases on that very point. No, okay. I don't know of any cases that evolve, but I suspect PERB would come out the same way. Yeah. That if the union puts proposals on the table that really are not designed to deal with the effects of this thing on employees, but really are designed to just stop management in its tracks. They are so draconian that even though they are effects on employees, but they're so draconian that if management agreed to them, they'd never be able to get by the max, or they'd never be able to do whatever it is they wanted to do. That, I think, but somewhere in the back of my mind, as I'm talking about this now, I think I saw something about this on RIFs. I think I saw something about this on RIFs. RIFs, by the way, are not a management right in the 617.08 sense. That is, management can't waive the right to decide RIF. Okay, it doesn't have to, and it can't bargain with the union about the decision to RIF. Okay, remember we're talking now about the decision. Effects talks about the effect of that decision on employees. You have to bargain with the management has to bargain with the union about the effects of RIF. But way in the back of my mind, and sometime I'll tell you what, I'll try to find it between now and our April section. But I just vaguely recollect PERB saying something about that it can't be so obstreperous. The union's proposal can't be so obstreperous that it blocks management from even from doing what it wants to do in the area of RIF. Okay. Okay, illegal clauses. Illegal clauses. Anybody get an idea of, anybody get an idea of a clause that could be illegal? Anybody have an idea of something that the union could propose, or for that matter, management could propose, that would be illegal? In other words, if you put it on they put it on the table, it'd be an unfair labor practice. Yeah, how's that? How about a clause that says we'd like to divide the workforce between blacks and whites? And we want a provision in our collective bargaining agreement that has that. Or we'd like, no, better still, the management says to the union, we'd like to have seniority lists, black lists and white lists, male lists and female lists, Catholics and Protestants, okay? Muslims and Jews. We want to separate everybody out into the groups that they like to, quote, they like to be with. All right? What if management proposed that? Would you think that was illegal? You bet your life it is. You bet your life it is. And it would be illegal if they just proposed it. Just proposing it would be an unfair labor practice. Okay? Not it's permissive, not that it can be waived. No. It's illegal. Okay? How about this one? Oh, here's a good one. The union says, we'd like a provision in the contract that gives us the right to strike. In DC government now, okay? Okay, we'd like a provision in our contract that would give us the right to strike. Is there a right to strike under PERB?
No.
No, it's illegal, right? It's illegal. Okay. Can they have it? Yes, ma'am.
What about benefits? So this local law requires.
Whoa, I haven't got an answer yet. Are you answering my question? Could they have such a clause?
To allow strikes?
Can they have such a clause in the contract?
No.
Okay. Well, that isn't what PERB said, and it was held, that kind of a proposal was held not to be illegal. Now, PERB says this isn't giving them the right to strike, but they actually wanted to put it in the contract just in case the law changed. Okay? And PERB says, well, that's okay, it's still illegal. Okay? Actually, I thought I wrote this down. I apologize. I should have written this down. I'm going to make a note to myself and get it for you. Anybody else heard about that case? It was a negotiability case, by the way. It was not an unfair labor practice. It was the union had it was a proposal in a union proposal. As I was reading it, I was taken back too, but PERB said it. Again, don't think for PERB made it very clear. This doesn't give you the right to strike. This certainly doesn't do that by any means. But as far as PERB is concerned, the union's saying, yeah, we'd like it just in case the law changes. We don't want to tie our hands now.
Why doesn't that apply to anything that's currently illegal under the law?
Well,
I'm interested in what difference,
how
they draw the distinction.
I don't remember. But I don't think PERB made that distinction, by the way. I'm going to see if I can find it. Next month. Come back next month and we'll tell you. All right? All right. An agreement to change RIF procedures would be illegal. Why? Because RIF procedures are set up by the thing called the Abolishment Act. And actually there's a PERB case on that. It's 14N-02. Ma'am? It was, by the way, that was DC Homeland Security. Anybody here with Homeland Security Agency? It was a 2014 decision. Let's see. See if I can quickly find. The PERB, PERB, the union said, we'd like a proposal that says, this is a negotiability case. We'd like a reduction in, the clause they wanted was, a reduction in force will be conducted in accordance with the provisions set forth in a citation to DC code. They wanted that in their contract. PERB said, nothing wrong with that. All you're right putting the law in your contract. But the next thing that the union asked for was, it said the agency shall provide the union with 30-day advance notice when a RIF includes members of the bargaining unit. And the agency further agrees upon request to participate in I&I effects bargaining concerning the reduction in force. Sentence number 1 there, not negotiable. Sentence number 2 was negotiable. Okay. Number 1 was 30-day notice, not negotiable. Agreement to engage in I&I bargaining, negotiable. Yes, ma'am.
Sorry, I was just saying, did you repeat the case number?
Oh, the case number here was 14-N-02, and if you have Westlaw, this particular case, it's 2014 WL 3887588. Repeat, 2014 WL 3887588. Okay. All right, just to repeat myself, even though there may be no decision to bargain or no obligation to bargain about the effects, about the decision, there may be obligations to bargain about effects. Okay. We are moving to number 4, which is the duty to supply information. Okay, any questions about 1, 2, 3? All right. We're gonna finish it. I know we're supposed to get through 11:30, but I'm gonna finish this today. I'm sorry. I'm gonna finish it. Well, I'll talk fast. All right. Both management and unions have an obligation to supply necessary and relevant information in collective bargaining. Why is that? It's because Congress and the DC Council, everybody who has anything to do, knows anything about labor relations at all, knows that the exchange of essential information is what makes collective bargaining work. Now, what kind of bargaining are we talking about? Well, bargaining for a new contract, that's area number 1. And the same thing is true when you're bargaining during the term of the agreement. In other words, you're bargaining over grievances, you're bargaining over other issues of contract administration. Because that's really what's going on. Sometimes we don't think about that as bargaining, but it really is. All right. Information obligations during contract negotiations. Let's talk about that first. The lead case on this is the Supreme Court's decision in Truitt. I don't have the citation, I'm sorry, but it's Truitt Manufacturing, okay? Truitt Manufacturing. It's a big Supreme Court case. And the court said, and I quote, "Good faith bargaining requires honest claims. Issues important enough for bargaining are important enough to require some sort of proof of occurrency." Or of accuracy, I'm sorry, I misread my notes. Some sort of proof of accuracy. Now, Truitt usually comes up in the private sector in what's called inability to pay cases. The employer says, "Oh, I can't afford to pay those wages, I just don't have the money to pay it." Well, the board has said, and the courts have said, when that happens, then the employer has an obligation, upon request of the union, to open its books. The union says, "You say you can't afford it?" The employer says, "Yeah." He says, "Fine, we'd like to have our auditor, our accountant, go through your books." The employer says, my books are personal, private. You can't have those. The Supreme Court says, no, they can. If they're claiming inability to pay, they've got to be able to prove it. If the union says prove it, you've got to be able to prove it. Okay? All right. Now, I will tell you that in the private sector, those cases are very, very hard to get that kind of an order from the board or from the courts, because nobody wants to force employees to give it up. But that's the law. That is the law if the employer is claiming inability to pay. In a very recent NLRB case, the union made a request for bargain, request for information. The employer ignored it. By the way, I see that a lot in deep PERC cases, but this is a private sector case. The employer ignored it. The parties went ahead and got a contract. The NLRB still prosecuted the employer. Okay? And when they got to before the judge and before the board, the employer says, hey, there's no need for that. There was no need for that information. You should dismiss this case. And the proof of that, there's no need for that, is the union agreed to a contract. And the board says, no, you misunderstand. Yes, that is the most that says is that the union just decided they were willing to go ahead, but we want to be sure that we built in an order against this employer. So the next contract, when he does it, it'll be a violation of our order. Yes, ma'am.
Was the remedy something else besides posting that we violated the?
Yeah, provide the union with the information, even though it's old news.
They ordered them to provide that
Yeah,
information.
even though it's old news. Yeah. Yes, ma'am. Okay. So there is an obligation to provide that information during the course of bargaining for a new contract. Okay. We'll talk a little bit about what kind of information you have to give up, what's relevant and what's necessary, but we're just talking now about the times in which you have to produce. The second time you have to produce information, request information, is during the life of the agreement, where the union wants the information to be sure that the contract's being honored. Or the union needs it, for instance, to judge the strength of the employer's claims about what it needs, what it wants to do. The union may also want it to eliminate non-meritorious grievances. In other words, the union has a grievance about tardiness. The union says, look, our guy who got fired for tardiness says that everybody else was tardy too, but you never fired them before. We want to look at all of the time cards for the past year to just see if that's true. Why does the union want it? Well, the union wants it maybe to help prove its case if it goes to arbitration. That's okay. But it also wants it to see if this guy was telling the truth. Because if everybody else who was tardy got fired, the union's going to say, we're not going to take your case to arbitration. It's a non-meritorious grievance. So it serves the employer's interests to provide that information. And as I said a minute ago, the union is entitled to that information to prepare for arbitration. I know you say to yourself, oh, I don't want to give this up. This is my ace in the hole. When I drop this on the arbitrator, I'm going to blow him right out of the water, and I don't want the union to be able to prepare for it. Well, I'm sorry. They've got a right to have that information. If they ask for it, they have a right to that information, and you don't have a right to blow them out of the water in those circumstances. Okay? Needless to say, if that information is that good, you're going to be able to blow them out of the water anyway. You know? Okay, how does this happen? What's the nature of the duty to supply information? Well, first there has to be a request. Okay, there is nothing that requires that the employer sua sponte just offer the union all the information that it wants, that the employer thinks the union might want. The union's got to ask for it. Okay. Information, that request doesn't have to be in writing, but if anybody here is a union person, I suggest you do it. But in law, it doesn't have to be in writing. And secondly, it doesn't have to be repeated. You say it once, get the message across. The employer's refusal to do it is an unfair labor practice. Now, I will tell you this. I was really surprised as I was reading the cases, how many cases I found in which a DC government, an agency, okay, just ignored information requests. I mean, it was just hard to believe. Or, better still, what they did was, some of these people, I think, are living in dream world, okay? They get the request, they acknowledge it. They acknowledge it. They say, we have your request, we'll be in touch with you. They never get in touch with them. And they think the union, it's like I think they think the union has Alzheimer's. That the union is going to forget they made the request. I mean, please, if those of you who are with agencies, okay, this is really what makes collective bargaining work. And by the way, this is what makes your relationship work with the union. You know, I mean, if you say to yourself, I'm a union guy, I'm a management guy, I wish we had a better relationship with the union. It'd be really good if we could really work together. And then you don't only request for relevant and necessary information? Or better still, if you've got a reason why you can't, we're going to come to this in a second, if you've got a reason why you can't give them the information, call them up and tell them that. Ask them to come to your office and explain it to them. Don't ignore it. I mean, no wonder the union gets mad as hell at you. You know? It's mind-blowing. It's a two-way street, okay? Because if you're a union and you are sending burdensome requests, you just decide, just throw it up on the wall and see if it sticks. We'll put everything but the kitchen sink in their information request and send it to the employer. Well, you're not really encouraging the collective bargaining process either. You know, ask for what you need, and then sit down and work with the employer if he's got a problem. I hate to sound like a priest from my parish yesterday, Sunday morning in Mass up on the pulpit, like I'm giving a sermon. But I hate to sound it, but I mean, there were so many cases that where this was it. I couldn't understand it. I could not understand it. Anyway, okay. So the information has to be relevant. It has to be a request.
Question.
Yes, sir.
If information requested is not, all is not disclosed, can it be introduced in arbitration, the undisclosed information requested?
Okay. In other words, I don't know if any of the people in the back of the room heard the question. The question is, if they don't disclose the information, can it be introduced into arbitration? Okay. That's a decision for the arbitrator, but I think most arbitrators would say, no, it can't be. Okay. We're not going to let you sandbag the union. Yes, ma'am. Yes, ma'am. I'm coming to that. Right? Actually, I've got a quote from PERB about this. I've got an actual quote from PERB. Who do you send the request to? There were two cases where they were. One was a Department of Mental Health case in 2012. It was something. There was an argument, a fight over pay, and the request was for information, pay information. The agency sent it to its payroll office or to the pay office. That's separate from the agency. Sent it to the pay office, and then just there was no response from the pay office. So the case went before PERB, and PERB says there's a violation here. There's a violation here. Why? Because this is one of those cases where you, the agency, could have pulled that information together. Even if pay office didn't respond, this is something you could have gotten. Something you had. Okay. They don't give a lot of detail in the decision. By the way, that case is 9-U-07. 9-U-07. Okay. But in a second case involving the Office of Labor Relations, a 2014 decision. It involved the Fraternal Order of Police, who of course have a contract with MPD. But FOP the Fraternal Order of Police sent a request for training information to the Communications and Labor Relations Office, not of MPD. This is a separate agency, right?
They sent it to OUC, Office of Unified Communications, and it sued Labor Relations for advising OUC.
Right, that's my next point. So then the union didn't get the information. They didn't get a response from OUC, and so they filed an unfair labor practice charge against OUC and Department of Labor Relations. Okay, and they lost. And the difference here was they just sent it to the wrong people. They don't, and as PERB said, they don't they don't have a collective bargaining relationship. There has to be a relationship between the requester and the requestee, okay? And in this case, it should have gone to MPD, okay? So, what should be in the request? Well, it should have the information you want, request for the information you want, but it should give the reason too. It should give the reason too. Now, I know that those of you who maybe taken a basic labor law course, you say, you know, I've heard about this thing called evidence, information that's presumptively relevant, and I know I don't have to make a case for that, but I admonish you, if you're making an information request. And by the way, it goes without saying, this applies to unions as well as employers. When the if the employer is making a request of the union for some information, it should give the reason why it wants that information, okay? As a matter of fact, if you want the case on this, I didn't write this down. I didn't write the name of this case down. I'm sorry. Anyway, oh yeah, no, it's a Metropolitan Police. I'm sorry. It was 9-U-59, and if you're a Westlaw person, it's 2011 WL 6978311. So per pitch, because the union, in that case, the union asked for information on change in policy regarding take-home police vehicles, and per pitched it because the union didn't tell the employer why it wanted it. Yes, sir.
Sorry, she asked about a length of time, and I didn't get a length of time to respond.
I'm coming to it. No, I'm coming to it. That's on page 18, and where did I? That's on page 19 of my notes. Okay. All right. Now, you know, I started giving you a little sermon about this thing, but let me just give you a couple of cases that I just wrote down the dates. February 18th. I'm not going to tell you who the agency was. February 18th, response. The request is made. March 4th, it's acknowledged, and quote was saying, we'll give you a prompt response, close quote. April 29th, the union hasn't heard anymore, they ask again. May 21st, the union still hasn't heard, they ask again. Now, what kind of a relationship is management trying to cultivate here when February 18th, by May 21st, having said we're going to give you a quick, prompt response, that was the word the management used. 3 months later, still no response. Now, if this was a problem, if there was a burden, sure, but call the union and tell them, you know. That's how you deal with your wives or your husbands, isn't it? That's the way I tell my my wife asks for something, I just say no. But I don't drag it out, I don't say, well, I'll think about it. I think about it. If the answer's no, honey, it's no. Sometimes I say I'll talk about it, but it's really service bargaining. Really service bargaining. Okay. I had another case. Request made January 13th, acknowledged on January 25th, saying, I'll get you the information. Second request, February 2nd, a week later, so maybe they never got the response. They just gave the information. Never gave the information. How long can an employer take? Well, the answer is, it depends. The answer is, it depends. There is no nice rule. There is a case, DC Public Schools case, 13-U-02, and again, if you're a Westlaw person, 2013 Westlaw 875-5706. It's the Westlaw citation. And the board said there, and I'm almost quoting them, is that 1.5 month delay is a reasonable period. 2.5 months is too long. That's what they said. Okay. Now, if I were you, I would not use this as a guide. I would really not use this as a guide. Okay. Because PERB was actually talking in the context of a particular case. But they said it. They said it, and maybe you can use, maybe you'll be able to help. If you waited 2 months and they filed an unfair labor practice charge, maybe you could use that in your defense if you're a management. Okay. But it's always going to be a very fact-bound determination. You know, it's always going to be on the facts of the case. If the union's asking for something that's very easy to supply and you drag it out for a month and a half, you deserve to get whacked by PERB. You really do. You really do. If it's a lot of material and it's not going to, you just can't do it in 2.5 months, well, you know, the answer is you call them and tell them that. Okay? Yes, sir.
Freedom of information request, FOIA request, is that different from?
Yeah, it sure is. It sure is. The question from the back is Freedom of Information Act request different than information request? Yes. First of all, Freedom of Information Act request, the union does not have any greater rights than your high school son to the information. In other words, if your high school son writes in and asks for information under the Freedom of Information Act, and the union asks for the same information, you both have the same standing. You don't have any greater standing. Okay, everybody has the same right. Okay. And the obligations there are statutorily done. Okay, Freedom of Information Act is different. Yeah.
And I think that this is an interesting dovetail on that. We recently had a request for all of the employee addresses from the union, and I mean, we asked for them to particularize the need, why they need the addresses and why they can't get them themselves from their own union members, because we were concerned about providing personal information which could reasonably, without our own supervision, once we've handed it over, become the domain of anybody within the union. We have no control over it, and yet that information is protected by passwords in PeopleSoft and so on and so forth. And so we're at 6s and 7s over whether to provide it.
Well, I think in the private sector you'd have to turn it over. My recollection is you have to turn it over. Certainly, in the private sector, the union gets it. The private sector, the union gets the addresses of the employees even before the union is certified. It gets it as part of the election process. You know, in other words, it's what's called the Excelsior rule. And we'll be talking about that next month, by the way. But if there's going to be an election in the private sector, the union gets the names and addresses of all the union employees prior to the election. So the union can go out to their houses and knock on the door and talk to them about why they should vote for the union. So I don't know what the personnel laws are in the District of Columbia. I don't know that. But I will tell you that I don't think you'd have much of a leg to stand up. Now, let's back up just for a second. This comes up now and then in strike replacement situations. The union strikes, the employer replaces them with what the union calls, quote, scabs, close quote, okay? People that the union really doesn't like, okay? And the union is yelling at them as they cross the picket line and all this kind of stuff. Yeah, we'll get you, we're gonna, you know, okay? And then the union comes in and says, we'd like the names and addresses of all of the strike replacements, okay? Now, these are hard cases for the board because, yes, the union's entitled to that. The union represents those people. They're in the bargaining unit. They may not like it. They may not like the union, but they're in the bargaining unit, like it or not. So the union has the right to know where its members live. The people it represents lives. The board has wrestled with that particular problem, saying in those circumstances, it's a different balancing test. And I think in some of those cases the board has said no. Or if the board has said yes, the Court of Appeals said no. It's been all over the lot on this. Did you have a question, ma'am? Was somebody back there?
Yeah, I mean, like,
Yes.
well, sometimes I think the delay is because you don't know what information can be provided to the group, just like the gentleman said up there. Like, for example, some of the stuff can be avoided, but it's kind of like, you don't want, you feel compelled to protect the employee's personal information. So sometimes they may say, well, I want to know the hourly salary of all of our members. Well, yeah, you can get that, that's public information. sometimes, but I mean, it's like, where's the line, you know?
Well, I'll tell you, the line is probably not where you're drawing it. It sounds like, I can't tell for sure. I'd like to know a little bit more, but remember who's asking for this, okay? It is the employees that you're trying to protect. It's their representative that asked for this. They may not particularly like it, but he or she is their representative. And they were using that as part of their collective bargaining responsibilities. And, you know, unless maybe you have a case like the one I just described, I don't know how much, does it really behoove you to be telling employees you know better than their representative?
Well,
I don't know.
If the employee comes to me and they're upset because I provided their personal
Yeah.
information, what recourse do I have?
Tell them
explain
tell them to talk to listen, let me tell you this. Let me tell you this. If this question comes up, I don't want to judge this because I don't know the circumstances. What you need to do is talk to my friend right here. He's with the Office of Labor Relations. Yeah, let him figure it out. He's getting paid the big bucks to figure this out. But I think there are. I know I'm coming along maybe a little stronger than I probably should. But I think you've got to remember that what this is all about. This is all about collective bargaining and about exclusivity. It goes all the way back to that. You know.
But I mean, we had requests where, and you know, we want all of the information on a particular job that was posted, and all of the applicants that applied for that job. I mean, of course, we call it labor relations.
Well, I'm going to go on. Let me go on.
You can't hand that stuff over.
Well, okay. Let's go on from this. What kind of? Because the next question. Oh, I got to talk fast. The next question is, what is relevant and what is necessary? Okay, that's the question. That's the question this lady's asking. What's relevant and what's necessary? Okay, and it must be evidence, information that's related to the collective bargaining relationships. If it is too general, if it is very general, you can't figure out really where they're going with this thing. Maybe that may leave it to the employer to determine what he's going to turn over. Okay, but it's almost impossible to give a much better guideline than this. And what I'm going to tell you is, the NLRB and I presumably PERB would tell you that the standard for what's relevant and what necessary is a liberal discovery standard. That's the term they use. In other words, it's the standard that the courts use in deciding what a plaintiff or a defendant can get in discovery from the other side. And those of you who have law degrees or know lawyers or talk to lawyers in your agency know that's a very, they always refer to it as a liberal discovery standard. That's the phrase they use because it is a very liberal standard. The courts have long since said, hey, when the parties are fighting about discovery, we're not going to get into every single fight that goes on. You turn it over and we'll figure out later whether it's admissible. So that's the best I can tell you. That's what the board and that's what the courts say. Liberal discovery standard. Yes, ma'am.
So does that mean the unduly burdensome?
I'm coming to this. I'm coming to that again. That's the next page. Yeah. Did you have? Is that your question?
It sounds like PERB is borrowing the standard from the NLRB, and so I was going to ask about in the federal sector. There's a statutory right to information here that talks about what this gentleman mentioned, a particularized need for information, and it's a little tighter than liberal discovery standard. And I just wanted to clarify that it sounds like PERB borrowing from the NLRB as opposed to the FLRA.
Well, I'm going to ask all my lawyers here to tell me. Did I misstate? He says no. I said it correctly. I said it correctly. Yeah. All right. Almost there. Which brings us to the last two, which is the questions you've been asking: burdensomeness and confidentiality. Okay, burdensomeness. You know, if the employer gets a request that it considers burdensome, what does it do? Well, it doesn't stick its head in the sand and say, "Oh, this is burdensome. I'm not going to respond to it." Okay, because you have an obligation at that point to come forward and contact the union and say, "Hey, this is burdensome. You're asking for relevant and necessary information, at least some of it is, but what you're asking for is, you're asking for the kitchen sink. And this is going to take half our budget to do this. Do you really need this? Okay, and call the union in and ask them. That's really what PERB says. Do I have a PERB case? I do not. But I have an NLRB case, and PERB always says it follows NLRB, an NLRB case of just within the last month. A case called UPS, 362 NLRB number 22. Okay? And again, this is the time when parties really need to make their collective bargaining relationship work. They really need to get together and try to work out this problem. You know, the union says, the employer says, look, you're asking for too much. Is there any way you can pare this down? And by the way, if the union says, no, we insist on everything, and indeed burdensome, employer wins. The union, at that point, the parties have an obligation under CMPA to talk, to bargain with each other about, to try to resolve their problems. This is not a game. This is parties trying to resolve collectively resolve their problems. Ma'am? 362 NLRB number 22. It's involve United Parcel. Same thing with respect to confidentiality. Okay? If you are really troubled by that, call the union and says, we're a little troubled about giving you the names and addresses. We really are a little troubled. Is there anything we can do short of that that will help you with this problem? Now, by the way, I think there's the answer to the union may say, hey, look, these are our employees. We want to know where they live. We want to send them newsletters. We want to send them a newsletter. You could say, well, how about if we distribute the newsletter at work? But I guess my point is, this is the kind of thing where you should be sitting down with the union trying to solve the problem. Okay? Now, if they're asking for medical information, whole different problem. Okay? That is confidential material. But can you just say no? I don't think so. I don't think so. You need to say, look, you're asking for confidential information. Is there anything I can give you that would solve your problem? Can I give it to you in the aggregate without any identifying information? Would that solve your problem? Union says, no, I want to know every jot and tittle about the health of every employee in the unit. Well, the answer is, I'm sorry, if that's your last proposal, the answer is no, and the union loses. The union loses. So in other words, the union has an obligation to come forward at that time. Again, it's collective bargaining. Yes, sir. Who had his hand up?
I did. So
oh, sir, I'm sorry. I'm sorry. Did I answer it?
Yes.
Okay, all right. Okay. All right. Just the last point. By the way, I'm leaving information. Any more questions about information? The last point. Just something, we're now finishing up on unfair labor practices, and something I did not mention before, but it's a good way of wrapping up the whole subject, and that is the whole subject of protective orders under CMPA. CMPA has a provision, well, no, I'm sorry. I take that back. It's PERB Rule 520, paren 15, close paren. Rule 520, 15, paren, close paren. And it's what that says is that PERB has you can come to PERB if you have an unfair labor practice case, and you think that by the time this thing gets through PERB, the remedy here will be totally meaningless. There will be remedial failure. You know, the lawyers will stretch this thing out so that by the time we get a PERB decision, it won't mean anything. I need relief now. You can, if you have that kind of a case, you can come to PERB and ask for, what do they call it? Preliminary relief. At the NLRB, they call it 10J injunctions. But it's the same principle. And if you're interested in it, there was a 2013 case involving the Office of Unified Communications, 13U-20. The PERB said no, by the way, in this case. in case involved unilateral change in the official time policy for union officials. Okay. And if you're Westlaw, it's 2013 WL 3489590. 3489590. Okay. All right, I'm going to, well, we went over a little bit, but we finished. Yes, sir.
That last case you just mentioned, you said, Herb said no because the OUC, the union didn't approve unilateral change?
No. PERB said they're not going to give preliminary relief. We're not going to give you the relief pending the final decision of PERB. Ultimately, the union may have won this case. I don't know. That's not the point, though. Okay. Let me just quickly tell you something. Next month, we're going to spend the next month talking about representation cases at PERB. We're going to actually have a movie. It's going to be an NLRB training film. You will see a mock NLRB election. Now, you say, well, hey, I'm in the D.C. government. If you've never seen an election by PERB, you need to see this film, okay? You just need, if you're going to be a labor relations executive, either on the management side or on the union side, you need to have some familiarity with representation cases. And that's what you're going to have next month. We'll show the movie and we'll talk about representation cases at PERB, election cases, unit modification cases, unit clarification cases, okay? See you next month.
Everyone, we're passing out a little survey. If you could just fill it out for us. I just want to get some information from you about any topics that you think we should be covering and how we can expand. Just let me know. I also have the notes from last month's meeting for you if you would like to pick them up. And I think that if anyone came last month and did not get a notebook, or if you don't have a notebook, I think we have some notebooks over there, don't we, Cheryl? We have some notebooks over there. All right, so thank you, and yes.
Are there videos of the last?
We're still working on a closed cap. We have to get closed captions for anything we put out, and so we don't have it yet. Okay.
I'm really worried about what this is going to look like. I'm really worried about it.